Okay, thanks everyone for coming. Sorry about the confusion regarding the podium. As you were all in the courtroom, we received the decision. The court's decision is that the questionnaires with regard to the nuclear DNA testing that has been deemed admissible by the court. I want to first and foremost thank the court and the court staff, court officers, everyone, for the hearing. I thought it was very well done as far as administrated by the court. So I want to thank the court staff for that. I want to thank the judge for his clearly very careful evaluation of the testimony and the evidence in the case. I agree with the court's kind words with regard to the briefing in this case. I think that this case was very aggressively and effectively litigated by both sides. I think that the reason why we were able to prevail were one simple reason. The science was on our side, and that's why we won. The science was on our side. And I also want to thank our witnesses, Dr. Navrosky, Dr. Harris, Dr. Green, incredible scientists, incredible people. They're very similar to the victims' families and the victims in this case. They're very inspiring to our prosecution team. They really are at the very top of their very challenging and competitive field. So we were very lucky to have them agree to participate in this case with us, and we'll be forever thankful to them as well. I want to specifically thank our team. Again, reiterate what the judge said. I thought we, both sides did a real great job. Our team, Nick Santamartino, Andrew Lee, Larry Opiso, Megan Power, Michelle Haddad, they did a fabulous job. So very thankful that this result is behind us. And now, as you heard from the judge, there was another motion filed with regard to an alleged a public health law violation, which we'll deal with, which we'll have our answer in before the next court date. And then we're proceeding along that way. We're fast reaching the pretrial stage, and we're hurtling towards the trial stage. So with that, I'll open up the floor for questions.
So what is your reaction to the defense's assertion in this motion that the DNA testing is in violation of the state's health law?
I said if I was running a blood bank, I'd be very nervous. But since I'm not nervous at all.
Did the judge say exactly why he made the decision he made?
Well, it's in a very comprehensive motion. I'm sorry, a very comprehensive decision. Andrew, do we know how long that motion? 27 pages. I skimmed it, but I haven't really looked at it. Those 27 pages worth of explanation and so. It was spelled out in that motion, which I haven't had a chance to look at.
What is the health violation? I know that you're focused on this case, but does this decision set a precedent, do you feel, for this type of DNA?
Well, as Dr. Harris said, this decision and this litigation marks, I think, a significant step in forensic DNA analysis, similar to first you had the use of DNA in the forensic setting, which was RFLP. Then you had to switch from RFLP to STR. Now we're seeing that transition from STR to whole genome sequencing, SNP to SNP comparisons, and this is where we're headed in the science. If you look at STR, STR looks at 20 loci. This technology looks at hundreds of thousands of loci. So I think when it started, RFLP looked at 7 loci. For CODIS purposes, STR looks at 20. This technology looks at hundreds of thousands of differences along our genome, hundreds of thousands of areas of polymorphism, meaning where we as humans differ from one another. So that is a very discriminating and exact technique, and again, it just mirrors the all the other fields, forensic fields and scientific fields that use this this evidence, so I think the criminal justice system is sort of caught up today.
Ray, bottom line,
I'm sorry, I'm just gonna,
Thanks.
so, yeah, so there was a question from one of the reporters with regard to there's a public health law that requires, if you're going to do certain testing, that the lab has to be licensed in New York State. There are, and we'll answer it in more in depth, but, real quick, that would seem to apply to people who are doing diagnostic work, like if you're doing blood centers, blood testing centers, and which means you're doing actual clinical work, where you're actually withdrawing blood from a human subject, as well as other reasons why we deem it not to be applicable in this case. And again, we went through the FBI for all of our DNA. So we follow the rules and the mandates brought down nationally by the FBI.
Ray,
What should the layperson understand about how this bolsters the prosecution's case?
Wow, that was really very impressive.
What should the layperson understand about how much this bolsters your case? I mean, for the average person who's watching tonight, you have evidence, right?
Yes.
But now you, if you're allowed
Well,
to use the DNA, what should the?
So I think what any case, and a particular cold case, it's not any one piece of evidence. And what we would urge, when the case, as the case proceeds, what we've argued is, if you look at all the evidence, right, it's significant. But particularly when you look at the interaction between all the evidence, that presents, we would allege. And assert a very compelling case. So we have now nuclear DNA, we have mitochondrial DNA, we have phone records, we have witness statements, we have financial records, we have internet searches, we have phone activity, and we have
pizza crust?
Well, that's the DNA. So we have, when you look at the interaction of all of that evidence, we would submit compelling, and obviously the nuclear DNA is a big piece of that, but not the only piece.
What do you make of this motion, though, not in its specifics, but the idea that yet another motion is being filed? How does your team react to that?
That's the business. We put our case together, and the defense challenges that case any way, shape, or form. Again, I think this case has been very aggressively litigated. I think we're, as prosecutors, we are aggressive in our pursuit of the evidence and our presentation of the evidence. The defense has been, equally so on the other side. So that's how it goes. And having done this for a while, it's just, there's always the next hurdle, there's always the next challenge. So we'll just deal with it on a one-on-one basis.
When do you expect the trial could commence?
Well, I think that's up for the judge to decide, but by the next court date, we're gonna have a very good idea when that is going to occur.
Have
What's
there
your
been any
expectation
talks?
of plea
Have there been any talks about a possible plea deal, especially now that this evidence is
No.
going to be used?
No, well, we just found out two seconds ago. But, no, as I've said, numerous times, we discuss the defense and the prosecution on every single case. We talk about a great many things, and this case is no different. But, it's really, as far as what happens, it's really not up to us. There's only one person who makes that decision, and I don't have access to that person.
Mr.
So
Peter-
I'm in the dark really as much as you guys.
And also back in chambers, you just said full steam ahead for trial, but was there any discussion about multiple trials?
Well, that's what the severance motion is, and when you look at the evidence, again, the evidence that, as all of the evidence comes together and is woven together, one piece of evidence necessarily proves the evidence against multiple victims. So for that reason, we think the evidence in this case is inextricably intertwined, and as such, it's appropriate to be tried as one trial. Obviously, defense disagrees, and the judge will make that decision.
Does
Not
this
the evidence.
ruling help strengthen that? You know, because this DNA kind of ties a lot of those cases together.
I mean, I think that's one of the, it does, because I think that's one factor where we have the nuclear DNA as to a number of the witnesses, a number of the victims. And again, that's just another factor which weaves these cases together. I think we're up to 9, this applies to 9 pairs, I believe, over, a number of witnesses, I believe. I mean, 6 victims. So obviously, that's a key factor in this case being inextricably interwoven.
Can you speak for the victims' families?
see
I'm
the
sorry?
numbers.
Can you speak for the victims'
Would they like to
families?
say anything?
Would they like to
No,
say
they're not
anything?
gonna say anything.
How are they feeling today?
Well, I think they're feeling, I think they're feeling relieved, and I think they're happy and pleased with the decision.
About the
Who's the
evidence, can
attorney?
you say, like, at this point, has the defense gotten all the evidence at this point, or do you still have to get them some? And where, I know you usually say, like, it's this many terabytes, this many pages.
Well, when you talk about evidence, right, they've certainly gotten all the evidence in this case. Now, whether or not they've gotten every single piece of paper that was ever even tangentially related to this case from 1993 to the present date, that's another question. But they have all the evidence. Now it's a question of, really painstakingly going through and making sure they get every single document. And that's the law in the state of New York, and, that's the rules we live by. That's a monumental undertaking. I don't think people understand quite how monumental it is, because you're talking about not only my office, not only Suffolk County PD, you're talking about the FBI, HSI, you're talking about Secret Service, you're talking about Sheriff's Office, you're talking about, I don't know if I mentioned State Police, and probably a number of other agencies that I haven't really spoken about. So we've got to make sure, hey, every single time a pen was placed to paper in connection or even tangentially related to this case, do we have it?
And what's the significance of you guys certifying the case at the next?
Well, once we certify the case, that means that we've done our due diligence and then some, and we've gotten every single document that we know of, and we're ready to proceed to the next.
So that closes the discovery process.
It marks a shift in the discovery process. I don't think the discovery process ever changes, ever closes, because again, there's no, investigations are continuing, information is coming in, public, whatever it is. So we'll be, as we get it, we'll give it out. But basically what we're saying is we've gone back in time, and on this date, this is every single piece of paper that we found related to this case from this date back.
Mr. Terry, how do you feel personally?
I'm satisfied. I'm pleased with the work that our team did. I'm grateful to our witnesses. I'm grateful to the court, and I'm ready to move on to the next thing.
Will this change other cold case prosecutions now that you can use this technology? And do you have any cases in mind?
Well, we've started our cold case unit. We've got, we've got a number of cases that we're looking at. We look at those cases individually, and obviously this is another tool in our toolbox, and we're constantly looking. When you look at old cases that have remained unsolved for whatever reason, one of the first things you do, whether it's phone evidence, whether it's DNA evidence, whether it's anything else, can new technology help us to gather more information? So this is going to be a consideration on each of those cold cases. Sometimes it's appropriate, and other times it's not. So we'll just have to take it on a case-by-case basis.
But does it increase the chances of more cold cases moving forward to prosecution, not just here, but across New York?
I would say yes, yeah.
DA, the 5 Jane and John Does on your cold case website. Have you received tips that may be significant to move the cases farther along? And could there be tips related to this?
I'm sure we've received tips. Whether they remain significant, well, that analysis will have to wait until and if we actually charge those cases. So, we're looking at everything, including tips, but it's all rhetoric. It's all talk until it results in criminal prosecution.
But you selected 5, and some of the geography was of interest to us where these victims were located.
Well, that's your job to speculate and to read into things. I can't speculate, so I won't. But those are the 5 cases we chose.
Sorry.
That's okay.
What's the judge deciding on this next hearing, 23rd? What's he expected to decide on?
So, there was the additional, a public health law, challenge to our DNA evidence, which they filed, and the judge, I believe, indicated that he is going to render a decision on that motion, as well as the outstanding severance issue.
But could the admissibility of this DNA, this type of DNA, play a key role if there are other victims in the Gilgo case? Like, in other words, is it significant in that sense that if down the road you're trying to prove other cases and?
Sure, it's significant as far as admissibility goes. Obviously, this is a technology that we've been relying on for quite some time, so it's really not going to change our methodology because we've been utilizing it. It confirms our methodology, for lack of a better word, and obviously for other jurisdictions, now, that I'm sure this is something that they're going to look at because it's now, it's admissible, at least in Suffolk County.
Right, could the defense have made this public health law challenge sooner?
Well, I think I believe they did, and I believe the judge told them, make a motion. So that's what they did. It was touched upon in a little bit of our argument. It was touched upon a little bit in their motion. I think what happened was they filed their original motion. We filed a reply. They replied to that reply, and in that they really spelled out that their objections under the public health law. And I think at that point the judge said, "Well, just put in another motion because it's kind of after the fact."
DA, just to be clear, someone mentioned other cases. You don't foresee any more superseding indictments in this particular trial, though, right?
No.
If they did win their challenge somehow on this public health thing, could you take the DNA to some other lab that is like New York State certified and do it all over again, or?
I think it's interesting that the technology is unfolding rapidly. So the landscape is very different in 2025, even from what it was in 2024. So again, this is the future. More in the beginning, Astria was sort of the one lab. Now there are more. So there are more labs, and fortunately, we're not going to have to consider that.
DA, would Rex Deriva be looking at 7 life sentences?
Yeah, he would. Yeah, all of the cases have life at the end of them, with regard to all 7 victims.
Okay, and could you say anything about the trial? Like, I know that the jurors, it's hard. You have to find jurors who are familiar with the case, and everyone on Long Island knows about this case.
Well, what we have to find is we have to find jurors who are able to, regardless of what they think or they may have heard or they may think they know about the case, can they swear to base whatever decision they make in the trial based upon the evidence that is adduced at trial from the witness stand or from whatever exhibits the judge allows. That's the standard. So that's the standard we'll adhere to. Obviously, there are a lot of people who have a casual acquaintance with the case. I don't think that automatically would preclude them from serving as jurors. Again, that's argument for the court when we get to that stage.
What's the current status of the Shannon Gilbert case?
Shannon Gilbert case is not part of this case.
It's closed?
The Shannon Gilbert case is not part of this case. So we're going to leave it at that.
Thank you.
Okay, thank you. Thanks guys.